So yes, we found that when the legislative intent is found based on the literal edges, the plain meaning of the words. I mean, for academic purposes, we call it interpretation, but when they have to go beyond it and look into the not just the letter but also the spirit, the purpose, etc., then we call it construction. But for the purpose of this subject, as we study, we will be using them interchangeably. We've seen that intention of the legislature, also known as sentential legis, is what the judges have to find when they interpret the statute. So even when they construe, they find the same thing. They are not to attribute their own meaning, but to find what has been originally or truly intended by the legislature. So there are many challenges to doing that we discussed, but one thing that the judges have to keep in mind, that they have to expound the law and not legislate, because it is not their role, it is not their responsibility, and it will not be legitimate for them to legislate because of many different reasons that we discussed. So that's what they are to do. They are to find the meaning using the rules, using the principles, which are accepted ways of finding out the legislative intent that we are going to discuss. We have seen that they are not to refer back to the legislators, because once they have legislators have legislated, their role becomes functus officio, that it is at the moment of legislating, whatever the intent has been will ultimately be considered as the intention of the legislature. But how do we know what they actually intended at the moment of enacting the legislation? Well, we can derive that only from what has been enacted. So the judges should not be overzealous and then they skip the the letter of the law and then just directly go into the purpose, spirit, etc. They first have to trace the meaning from the words themselves, and only in difficult situations that we are going to discuss would they have resort to other help. So that's what we discussed. We also discussed some jurisprudential discussion, debate on the same issue. So that's what we essentially discussed. So a word of caution for judges is that Lord Watson had said, in a court of law or equity, what the legislature intended to be done or not done can only be legitimately ascertained from that which it has chosen to enact, either in express words or by reasonable and necessary implication. So that's what has been said. So the only legitimate way of tracing the legislative intent firstly would be from express words, okay? And if that's not sufficient in those exceptional situations, can it then find the meaning based on reasonable or necessary implication? So this is what has been said. So that's what interpretation is all about. It is to find the legislative intent, the true meaning of what is there in a legislation. Now there are lots of, the debate does not end here. You can go on reading as much as you want on this. It doesn't end there. There are lots of other, important philosophical as well as, other sort of discussions are there on this question. That, are we saying that judicial legislation does not exist? And what if the judges do in fact legislate? What if what the judges do, the kind of legislations that the judges do, what if those are better than what the legislators do? In such situations, should the better law, which it is possible that judges do enact a better law, should that, because it is better than what has been enacted by the legislature, should this not then precede the laws made by the legislature? So there are so many questions, so many discussions that we can have. Apart from that, we will go into all those philosophical discussions later on. So we'll leave it here for now. And today we proceed on to the next important, small, short topic. That is, we discussed till now that about what is interpretation and what is construction. Now, interpretation and construction of what? So the subject is of interpretation of statutes. So obviously it has to be statutes, and it is statutes interpretation that we are concerned about. So I probably need not tell you what statute is. You guys already know about it, but just for the sake of it, okay. So a statute is nothing but enactment, an act enacted by a legislature, okay, which is expressed in writing, because we have to trace the meaning from what is written, okay, from the letter, okay. So those letters are written, okay. So we have to find the meaning from what has been written. So, and a statute is that's why an act of the legislature, okay, that declares, okay, something. It could declare something. It could command you to do something. It could prohibit you from doing something, okay, which is expressed in writing, okay. Now that's not the end of this definition, okay. So you can expand it. As you know, that statutes are not merely in the form of command or prohibition. It could also take the form of authorization. It could merely declare, it could negate, it could amend. There could be many specific forms that it takes, okay. So this is what broadly it is, okay. So statutes are basically what is enacted by the legislature, okay. So the legislature could be whatever. It could be at the municipal level, it could be at the state level in a federal system, and it could also be at the federal level in a federal system. So that's what broadly statutes are all about. So now when it comes to statutes, there are many different kinds of statutes, okay. You can classify statutes into many different kinds. Now, how do we classify statutes? There are three broad ways in which we can classify statutes. You will find this in the book that I suggested yesterday in BM Gandesh. There, in the introductory portion, it has been discussed. So you will find it there. So statutes, which are enacted legislations, in written form. So they can be classified based on based on three different approaches, okay. First, we can classify based on the object, okay, for which the statute has been enacted. Then by the method with which it has been enacted, and thirdly, with respect to time, okay. So based on these three different approaches, okay, three different ways, the statutes can be classified, okay. So let's start with classification based on the object, okay, the object with which statutes enacted. So the first classification based on an object would be declaratory. I mean, it's not in that order, okay. It's not in that order. These are just classifications. So you have declaratory statutes. So what are declaratory statutes? As the name itself suggests, okay. So maybe there are certain doubts with respect to the existing state of the common law. Maybe there is no codification. So maybe we have some doubts about what the common law really is. Maybe there are certain confusions, or maybe with respect to existing statutes or other enactments, okay, there are certain doubts, okay. We do not know what's the correct way of reading it, okay. So that doubt can be removed by passing an act, okay, an enactment, which basically declares what the correct meaning is. So this is what is done, okay. So it is possible that quite often courts come across this difficulty, okay. So it is possible that they have been giving a particular expression in a particular law certain meaning, okay, but then legislature thinks that the way the court has been giving meaning to a particular expression is wrong, okay. In those situations, what the legislature can do is they can pass a declaratory statute, and then basically they clarify what the correct meaning is, okay. So this is what declaratory statutes are all about. Now the problem that arises is with respect to how the declaratory statute, and what is the effect of declaratory statute. So we know that the declaratory statute clarifies, okay, it removes certain confusion, certain doubts that we had with respect to meaning of a particular provision in a particular statute. So the legislature enacts a law to fix that mistake, to fix that error which was committed by the court. So in subsequent matters that come before the court with respect to the same, if the court were to deal with the same expression with respect to which the declaratory statute has been enacted, which meaning would the court give to it? It has to be the one that has been declared through the declaratory statute. Because as you know, why is that the case? It is simply because that it is the business of the legislature to enact laws. It is the business of the court to apply the law as has been laid down by the legislature. So even if the declared meaning is different from how it was interpreted by the courts, because the law has been enacted, the court has to now go with the new meaning which has been declared through the declaratory statute. Now the question is, what about matters which have already been decided? Matters with respect to which, matters with respect to which the said, particular expression has been applied in the past cases. Now the past cases which have already been decided, with respect to that, the new meaning does not apply. I mean, it does not change everything. However, if a matter has been, decided by lower courts, then it has been appealed to any higher court, and by then the declaratory statute has been enacted. Now in that situation, because the legislature has clarified what the correct meaning is, in that situation the court will go ahead with the new meaning which has been declared through the declaratory statute. So this is this is what declaratory statutes are all about. So are you there with me so far? Am I making sense?
Yes, sir. Yes, sir.
Yes, sir.
Okay. So do you see, I mean, here the hierarchy you have to see throughout all the different, principles and rules of interpretation that we discuss. It's going to be this rule that you will find everywhere, that it is the business of the legislature to enact laws. It is the business of the court to apply the law. So what the court thinks to be the right meaning will not supersede with what the legislature thinks is the right meaning of a particular expression in a particular enactment. So if the legislature clarifies that, then that will supersede whatever the meaning that the court gave to that particular expression. That's what we do. So so that's your declaratory statute. So the next kind of statute, based on object would be your consolidating, and I mean these are two different criteria. So you have codifying statute and then you have consolidating statute. So codifying statute, what are they? So maybe you had common law, and you did not have any statute law, so maybe you had common law with respect to a particular matter, but because it is necessary that there is some necessity of clarification with respect to the laws, so in those situations the existing laws are codified by the so like CRPC, criminal procedure code, civil procedure code, these are your codified laws with respect to that entire subject matter. When the law is put in an enacted form, you can call it codified law. Now you can see that not just those codes though, just because it says code, it's not necessary. Now look at the personal laws that we have in India. In 1955 and 56, most of the Hindu laws, which earlier were scattered here and there, maybe they were customary practices. So many things have been now enacted into statute, and they are quite comprehensive in how they have been enacted. So you can refer to them as codifying statutes. So it's very important the codifying statutes are very important, and they have their own special place. And the problem that arises with respect to codifying statutes as well as the consolidating statutes, now what's the difference between these two? Difference is not that much though. What happens in case of consolidating statutes is that you might have scattered matters in different statutes, and the legislature thinks that, well, it's better if we bring all those scattered statutes together and put them in a consolidated form. So that can also be done. So I think the code of criminal procedure would be a good example of consolidating statute as well. So, and then apart from that, you have Arbitration Conciliation Act of 1996. Those are examples of consolidating statutes. So what happens in both the cases is that in case of codifying statutes, you had customary or common laws which are put into a statutory form, and those are basically quite comprehensive, and hence you can call it codifying statute. And then you have consolidating statute, where different enactments, scattered here and there, are consolidated, and now you have consolidated statutes. Now, the thing that we have to look at is how they are to be interpreted. How they are to be interpreted. So, as you know, once the law is put into a codified form, whether it's a consolidating statute or codified, codifying statute, the rule is this, that when the judges are to trace the intention of the legislature, they are to trace the intention from the letters that you find in the codifying or the consolidating statute. You do not go to the judges should not at the very first instance go back to the previous state of law. They would not do that. They are to trace the meanings. They are to trace the intention of the legislature from the codified law or from the consolidated law. So Lord Herschel had said this, that I think the proper course is, in the first instance, to examine the language of the statute. So as I told you, you have to look at the literal edges. You do not go and look at the state of law as it existed before this codifying or consolidating statutes. So he says, I think the proper course is, in the first instance, to examine the language of the statute and to ask what is its natural meaning. He's talking about the grammatical rule here. Uninfluenced by any considerations derived from the previous state of law. So as a judge, if you were to decide a matter based on the codifying or consolidating statutes, you do not look at what the meaning of that particular expression has been in the previous state of laws. You are to look at the literal edges now and then draw meaning from that statute. You do not look at the law as it existed previously. So that's what he's saying. Uninfluenced by any considerations derived from the previous state of law, and not to start with the inquiring, how the law previously stood. So you should not bother how the law previously stood, because we are concerned about the intention of the legislature. We are not concerned about the intention of the earlier legislatures, but the law which has been enacted by this particular legislature. And where do you find it? You find it in the concerned statute. So that's what is being said. And then he said, and then assuming that it was probably intended to leave it unaltered, to see if the words of the enactment will bear an interpretation in conformity with the view. So that's what you do not do. You don't assume that, well, the new legislature wanted to leave the meaning of a particular provision unaltered, like basically what it was earlier. You are not to assume that. If a statute intended to embody in a code a particular branch of the law is to be treated in this fashion, it appears to me that its utility will be almost entirely destroyed, and the very object with which it was enacted will be disturbed. Recourse may never be had to the previous state of law for the purpose of aiding in the construction of provisions of the code. If provision would be of doubtful import, such resort would be perfectly legitimate. So you see what the order in which the judge has to go. If a matter comes before the court, okay, the court has to decide the matter in the light of the new codifying or consolidating statute. Okay, that's what the court has to do. It will not go back and then see what meaning was there with respect to that particular similar provision in the previous law. Okay, so that's what courts are not to do. Okay, courts should not do that. They are to draw the meaning from the newly enacted law. Okay, that is the codifying or the consolidating statute. The rule applies in both the cases. Okay, now suppose a situation arises, okay, where the courts facing some difficulties with respect to deriving the correct meaning, the true intent of the legislature. In such situation, it can then take help from what is known as external aid to interpretation. That's something we will discuss later on. Okay, so you have internal aid and then you have external aid. Internal aid is from within the legislation. External aids will be what is from outside the legislation. So you will study about statute in pari materia later on. Okay, so anyway, I should not confuse you with all that. What has been said by Lord Herschel in this quotation that I just told you is that in those situations where judges come across such predicament, such difficulty, where they are having difficulty in tracing the true intent of the legislature from the letter of the law itself and using other internal aids, if it is difficult for them to do so, in those situations, okay, in those situations only, it would be okay for the judges, he says perfectly legitimate for the judges, to look at the similar provisions in the previous law, which this particular law claims to codify or consolidate. In that situation, it will be perfectly legitimate according to Lord Herschel to look at what the meaning has been in the previous law and then interpret the current law in the light of the previous meaning. So are you guys with me with respect to this till now?
Yes, sir.
Do I make sense? Any doubt what I was trying to explain?
No, sir.
No. So it's very simple. Okay, the whole subject, as you will see, is all about that. Okay, there is a particular order in which the judges are to go. If you understand that, then it will be very simple for you. So it has been said that it's only in those exceptional situations, okay, where, tell me.
Sir, I just wanted to add something. We were discussing declaratory statutes, sir. So, I mean, one example that I would like to give is that recently, sir, Arbitration Act was amended into 2015. So, sir, one provision is in Section 34, which says what are the circumstances in which an award could be set aside. So, sir, Section 34 used the term public policy of India. So if an award is in contravention with the public policy of India, it would be set aside. But Section 34 did not define that particular phraseology.
Okay.
In 2015, that thing was defined, and it reads, for the avoidance of any doubt, it is clarified that an award is in conflict with public policy of India only if, and 3-4 grounds are given,
mentioned
which
there.
Tends to define public policy of India.
Okay. So it tells you what specifically public policy means in that context.
Yes.
So such amendments, such changes. Okay. No, was it a separate statute or was it
Amendment Act of 2015, sir?
Okay,
Amendment
so
Act.
through amendment as well, certain declarations certain clarifications can definitely be made. So that would be a case of, but then there could be separate declaratory statute completely like altogether. Okay, a statute which is enacted solely for the purpose, but quite often it is done through amendment. So perfectly the case for a declaratory statute. So as long as it tells you what the correct meaning of a particular statute is, okay, how the judges are to interpret, then you can very much say that is a case of a declaratory or a clarificatory statute. So a good example that you have cited here. So I hope you guys are with me even with the other example that we took, codifying and consolidating statute.
Yes, sir. Yes.
Okay.
Yes.
Even there the idea remains the same, that the intention of the legislature has to prevail. Okay, it is not what the judges think that it is. Okay, it has to be the intention of the legislature, and intention of the which legislature? The legislature that has enacted that particular statute, not what existed before enactment of that statute. So that's what has been said here as well. While interpreting, consolidating, and codifying statutes, the judges are to look at the instant statute, which codifies or consolidates the law. Okay. And only if the meaning is not clear from the literal edges itself, okay, only in those difficult situations, in those in exceptional situations where it is very difficult, using the internal aid, the purpose, etc., only in those situations would they go to the external aid. So previous legislation becomes an external aid for the court to find the true intent of the legislature. Now, why do they do so? Why? I mean, when, for example, Lord Herschel says that it is perfectly legitimate for the judges to do so. Now, where does that legitimacy come from? It is this, that when the laws are codified or consolidated, the legislature, obviously, they want to bring changes to the existing laws. Okay, obviously, they want to do that. And if they do that, they will make it plain and clear in the statute, in the literal edges itself. Okay. However, they do not want to completely transform the law. They might just, bring scattered laws together. Okay. In such situation, we may also assume that it was the intention of the legislature to continue with the previous meaning with respect to that particular provision. They didn't want to completely alter. So it is with that, assumption in the mind that Lord Herschel said that in those situations, okay, of, doubtful import, such resort to previous, legislation would be perfectly legitimate. So do you get it, what Lord Herschel is talking about?
Yes, sir.
Okay.
Yes, sir.
So it was said in the case by the name Bank of England versus Bagliano in 1891, and it is accepted. Okay. We have a few Indian cases as well. Okay. In Joseph Peter versus State of Goa, it was said the court laid down that the code is self-contained and complete. So if a code is created, it is self-contained and complete, and that marks a distinction between the code and ordinary law. Okay, so when a law is codified, you are to assume that, well, the code is complete in itself. Okay, you do not, as a judge, you do not look at something outside the code, because when we know that when a code is enacted, it is to be a comprehensive law of that particular area. Okay, so you are not to look outside. But in exceptional situations, okay, where the code does not, provide you a clear meaning, as Lord Herschel had also said, okay, in order to remove certain doubt, okay, where the code itself is silent, okay, then you can have recourse to the previous law. Okay, so it's only in those exceptional situations where you cannot remove the doubt by looking at the literal edges of the code itself will you be justified in looking outside. But when I say looking outside, in this instant, I'm referring to the previous state of the law. So I hope this is clear. Okay, so and then the next kind of statute would be remedial statute. Okay, now the name itself tells you what remedial statutes are. A remedial statute, as the name itself suggests, okay, it provides certain remedy. So there were certain difficulties, okay, there were probably some harshness, okay, with respect to previous statute, okay. In order to, maybe there were certain defects with respect to a previous statute, okay. So in order to provide remedy for that, okay, remedial statutes are enacted. So remedial statutes are those statutes that provide a remedy. So it lessens the rigor, it lessens the harshness that you find in a previous statute. So it essentially what it tries to do is it redresses certain grievances that you might have, okay. And it might also give you some better better procedure that some new, even newer provisions which might be better for the public good. Okay, so remedial statute lessens the rigor of a previous statute, which might have been difficult, which might have been a little harsh. Okay, so it is a kind of beneficial, okay, statute. It provides some benefit, it provides some improvement, okay, it provides certain remedy. The intention is to lessen the rigor of a particular statute, of a previous statute. Okay, so it is quite often done with the intention of providing you additional benefits, additional remedy. It is done with the intention of providing you with certain welfare measures. Okay, so if statute is of that nature, we call it remedial statute. Now the difference here is this, okay, as opposed to remedial statutes, you have other statutes. Okay, so for example, penal statutes. Okay, now the rule of interpretation which is applied with respect to penal statutes is that of strict interpretation. We will not necessarily in all cases though, but the general idea is that with respect to penal statute, it is the interpretation which is given is strict interpretation. So you are to strictly as a judge adhere to what is written. You are not to enlarge or decrease. The same goes for even taxing statutes, but there is a difference we will discuss later on. But when it comes to such beneficial statute, okay, welfare statute or remedial statute, okay, the idea for the legislature is to provide you with remedy, to provide you with certain benefits, do some sort of social justice. So in those situations, okay, because it is enacted with such purposes, what kind of approach should the judges take in interpreting them? So in those situations, the judges take a kind of liberal approach to interpreting beneficial, remedial or beneficial statute. Okay, so what happens in these statutes is that if there are two interpretations of a particular provision possible, one that gives it very restricted meaning, the other one which has the tendency, okay, you do not go beyond your limits and then give that meaning. It's that you have two different options here. If you go for one that restricts the ambit of that remedy which has been provided, whereas if you go by the other, it increases, enlarges, not unduly, okay, the one which is allowed by the object and purpose of the statute. If you have these two options, then you as a judge will go with the one that allows you to expend the remedies, the welfares, the benefits which are provided under the statute. Okay, so most of these welfare statutes are to be interpreted liberally. Okay, so in India you have many such labor legislations. Okay, you can consider them as such welfare or remedial statutes. So if you as a judge were interpreting that, then you would give that liberal interpretation, because the purpose, you assume that the legislature exists to do good to the society, to be human to its people, okay, who are governed, who are ruled. Okay, so judge's assumption would be to not restrict that beneficence which the legislature directs towards the people. So its approach should be to enlarge, to assume that yes, this is what the legislature intended to do, and not to restrict the application of the said remedial statute. So are you guys with me? We will discuss this in greater detail when we discuss liberal interpretation later on, strict and liberal interpretation later on. So that's your remedial statute. Okay, most of your labor legislations are, you can take them as remedial or welfareist statutes. And then the next kind of statutes that we have are enabling statute. Now see, these are not very difficult for you to understand. Very simple. Enabling statute says that, well, formerly certain powers, okay, certain did not exist. Okay, so subsequently a statute is enacted that enables, that empowers you to do that. Okay, so it gives you the power to do something that you didn't have earlier. Okay, if the power, these are kind of power conferring statutes. Okay, so if the statute, okay, have been passed to enable you to do something, okay, which you were forbidden or you were prevented from doing, okay, earlier, so such statute can be considered as enabling statute. Okay, so that's there. So any statute that confers power on you that you didn't, that you didn't have earlier can be considered as an example of enabling statute. So as simple as that. The next kind that we have are curative or validating statute. Now what are those? So you know that when administrative authorities, certain public officials, administrative authorities, they function, their actions are legitimate only if they are acting in accordance with the legislation, the enactment that authorizes them to do something. Your legitimacy of your action would be based on whether it is in accordance with the power which has been conferred upon you by an extant statute. But quite often it is possible that such authorities do something which is not authorized under a particular statute. What happens then? Obviously, your act is tainted by illegitimacy because it is not in accordance with the power conferred by a statute. So in such situation, it is possible for the legislature to enact a legislation so as to validate an act which, in the absence of this curative or validating statute, under the old law would have been improper, would have been void. So these laws, as you have guessed rightly, are obviously of retrospective effect. So they retrospectively validate or fix, or cure an act on the part of public officials or other administrative authorities, which in the absence of this curative or validating statute would have been void, invalid under the previous laws. So those would be cases of curating or validating statute. Are you guys with me with this? Did I make sense?
Yes, sir.
Yes, sir.
Okay, so very, very simple. Okay, the next would be amending statute. Now this is a broad category again. Now I probably need not explain this. So certain changes in the a statute are to be brought. You want to probably remove something or you want to add something. As if the legislature wants to do something like that, then they make amendments to the statute. So amendment means what? Change. So if the legislature wants to bring change, they bring it through amending statute. So yeah, that's what amending statutes are all about. I'm not going to go beyond that. Along with this, we have another category known as repealing statute. Now this is a little confounding category. Sometimes repeal is done explicitly, sometimes the repeal is done impliedly, and you have to read the repealing statute properly to be able to tell what the statute actually means. And what is the effect of repealing statute? Those things need to be looked at. So the repealing statute basically repeals whatever statute existed earlier. It repeals the earlier laws. Now how do we interpret repealing? What is the effect of repeal? That is something that is very important for us to look into. Now with respect to that, you have to refer to section 6 of General Clauses Act 1897. What is the effect of repeal of a particular act? So with respect to this, just refer to section 6 of General Clauses Act 1897 that specifically deals with effect of repeal. What happens when a law is repealed? So it says, I will just read it out. It says, where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, obviously it will be subject to different intention, the repeal shall not, what would be the effect? The repeal shall not revive anything not in force or existing at the time at which the repeal takes effect. So what are we to assume? When the repeal happens, that repeal shall not revive anything not in force, or existing at the time at which the repeal takes effect. So it further says the repeal shall not affect the previous operation of any enactment so repealed, okay, or anything duly done or suffered, thereunder. Then it says affect any right, privilege, obligation, liability acquired, accrued, or incurred under any enactment so repealed. Okay, so you do not just negate it. Okay, the act which has been repealed, that also had the effect. Just because it has been repealed, you do not revert back to what existed before and then affect the parties right now. So that's what has been said. And then it says the repeal shall not affect any penalty, forfeiture, punishment incurred in respect of any offense committed against any enactment or so repealed. Affect any investigation, legal proceeding. Okay, so this you can go ahead with. Okay, so it just talks about the different, what happens when a particular, statute is repealed. And then we have two other kinds of statute, okay, based on the object. This is something that we are going to discuss, okay. So as opposed to the other statutes that we discussed, okay, so that is your remedial statute. You have these two different kinds of statutes known as taxing statute and penal statute. With respect to this statute, as opposed to the other, we go ahead with strict interpretation, that we go ahead with what is written in that statute, okay. We do not based on inference enlarge the applicability or reduce the applicability of what is mentioned in the statute. So that's there. So these are the classifications based on the object. Yes, yeah, Tripti. Anything, Tripti? Are you there? Okay, the rest of the people with me, any difficulty?
Yes. No, sir.
No, sir.
Okay.
No, sir.
No, sir.
Okay.
I switched on my mic then.
Okay. So the next kind of classification that you can make is based on, okay, what it does. Okay, so what does the statute do? So it's basically what it tells you to do. Okay, so based on that, okay, you can classify statutes into either directory statute, okay, or mandatory statute. Now, I mean, how do you know that something is directory statute or something is a mandatory statute? I mean, if something is written in the preamble itself or in the long title, barely it's written like that. But if something is written in the preamble, okay, can you take that and then assume that the entire statute goes like this? Okay, the entire statute is mandatory or directory? No, it's not like that. You look at specific provision and then assume whether it is mandatory or directory. Okay, but such classification can nonetheless be made. Okay, so what is a mandatory statute? A mandatory statute, okay, is the one, okay, where the provisions or requirements, okay, if they are not complied with, that will render the proceedings to which it relates illegal or void. So you as an official have to mandatorily abide by what is there, what the statute commands you to do. Okay, so you do not have an option. Okay, it's mandatory. Whereas in case of directory statute, it's probably better to say directory provision, because the entire statute need not be only mandatory or only directory. Okay, but it's quite often it could be. So in that situation, okay, if it is a directory statute, then you have the option. It gives you the choice. Okay, so that's the distinction that we can make between mandatory and directory statute. Now, one last classification that we can make of statute would be in terms of time. Okay, so what would that be? So you could have a certain temporary statute, and then you could have permanent, also perpetual statute. Okay, so what are temporary statute? So temporary statutes are those in which the time period is fixed, okay, for which the statute shall remain effective. Okay, so for example, this statute shall remain effect until so and so date. Okay, so that's a temporary statute. On the day of on the day that it elapses that time, the statute becomes ineffective. Okay, whereas so that most of the statutes are not of this nature. Whereas those statute that does not mention such period time, okay, such fixed period of time, okay, all those statutes will be considered as permanent or perpetual statute. Okay, so these are what different kinds of statutes are. So are you guys there?